Well, good morning, Houston Realtors. Welcome to a webinar today about contracts, forms, and things that aren't there. I'm Nancy Herzig, and I am your presenter for today. Marilyn Maxwell is with me just to make sure that I don't push the wrong button and lose you somewhere along the way. Just a little housekeeping stuff. Up in the right-hand corner, you'll see a question mark. That question mark is there for your use should you want to ask a question as we go. We're going to talk about some things today that are certainly review, and I don't want to go ad nauseum about these reviews, but as I find out in the field that agents are still not getting it, I keep bringing it forward so that the ultimate that all agents understand things that have been in effect for a while will be true. Finally, we will record this webinar, so I will take questions occasionally. I'll take a look at them as they come in, and if they seem like they're really urgent, I'll stop and do my best to answer it. Otherwise, rather than be disjointed about what we're doing, I'll do breaks here and there and catch up on the questions. So that being said, let's go ahead and get started. Okay, we're going to start with the contract. And I'm going to talk a little bit about paragraph 2, D as in dog, exclusions. I have had lots of questions about this in my teaching of the contract. And I want to be sure that everybody understands how this works. The exclusion paragraph says the following improvements and accessories will be retained by seller and must be removed prior to delivery of possession. That's all fine and good. Now here's where the problem comes in, is that items excluded by way of the listing agreement do not automatically become part of any contract. The contract paragraph 2D still must identify the property to be removed by the seller, or there are no exclusions, because the contract trumps the listing agreement, the contract trumps the buyer's rep agreement, the contract takes precedent over everything. So if you have exclusions for the seller, be sure that you carry those exclusions forward into the contract, even if paragraph 2D that you received from a buyer's agent does not have anything in the field. You have to have it there or the seller can't take it. And if the items if the items are included in MLS to convey to the buyer, it's usually the washer, dryer, and refrigerator up in the text of the MLS. Those items also do not automatically become part of the contract. A non-realty addendum must be prepared if personal property is to convey or no personal property is conveyed. And the contract takes precedent over the listing agreement and MLS and everything else. So what's your risk here? It's pretty high. If not handled properly, there may be liability on the part of the agent to make it right. I have seen agents have to replace washers, dryers, refrigerators, all of them, because the buyer thought they were getting them and they didn't get them because they weren't in the contract. So, earnest money. Paragraph 5 of the contract says that within 3 days after the effective date of the contract, that the buyer will deliver some amount of money as earnest money to the escrow officer. What goes in that blank is the name of the title company. It is not the name of your favorite closer within that title company. The escrow agent, as defined in the second line of the contract, is the title company. The escrow officer is the designated closing officer. The risk of putting the name of the escrow officer in the blank is primarily an error that will need to be corrected down the road. There's nothing terrible that would happen, but it's one of the biggest annoyances that license holders have who know how to fill out this paragraph with those that apparently don't know. So try to remember who the agent is and who the officer is. Next, we're going to talk about one more time the 3-day rule for earnest money. Last year, the contract was changed to read from execution of the contract to within 3 days after the effective date, that the buyer must deposit earnest money with the escrow agent, right? And now what happened here is that we took away business days. Everything is calendar days. But they made provision in the contract and in the law to be automatically extend the day if the third day is on a Saturday, a Sunday, or a legal holiday. If any of the other days, day 1, day 2, fall on a Saturday, a Sunday, or a legal holiday, the earnest money deposit is not extended. It only applies if day 3 falls on a Saturday, Sunday, or holiday. So, also, the seller now has the right to terminate the contract if the buyer does not deposit the earnest money timely. Now, it doesn't work if the buyer is late in depositing earnest money, but deposits it late, but before the seller sends a notice of termination. So you can't terminate the contract if the buyer is late and you haven't sent the termination. So I hope that's clear. There's a new form called seller's termination to use in the case of the seller exercising this option. And time is of the essence is added to the paragraph, meaning that the time frames are serious, so don't overlook them. So let's take a look at the chart one more time that was sent to all of us, compliments of TAR. Example 1 is just a regular old contract. So you get the contract, you sign it on Sunday. Day 1 is a Monday, day 2 is a Tuesday, and day 3 is a Wednesday. Earnest money is due on that day. That's easy. Now, weekend and legal holiday fall on third day. So let's take a look at what happens there. You have a contract effective date of Wednesday. Day 1, it's Thursday. Day 2 is Friday. Day 3 would ordinarily be the deadline for earnest money, but it's extended to the next business day that is not a Saturday, Sunday, or legal holiday. So we skip Saturday, we skip Sunday, and what do you know? We have Monday as a legal holiday. So day 3 of the time to deposit earnest money is extended until that Tuesday, and it must be delivered by close of business on that day. Now, it doesn't say 5 o'clock in the contract, but title companies close their doors and lock them, as a matter of fact, and turn their phones off at 5 o'clock. So it must be in before the title company closes for the day. Now, here's an example of a legal holiday and a Saturday falling on the beginning of the contract. So Thursday is your contract effective date. Day 1 is Friday, and it is a legal holiday, but it's not day 3. And so Saturday is day 2, but it's not day 3. Sunday is a Sunday, and so the earnest money is due the first business day that comes up next, and that would be Monday, day 3. So you had both a legal holiday and then a Saturday in the time period here, and they just go along and get counted. It's only day 3 that you're concerned about is whether earnest money can be moved forward or not. If you have any questions about this, be sure you talk to your broker or your team leader or any title company. Some title companies even have these charts available for you. So I hope that everybody understands this really thoroughly now. I just had a contract last month where the buyer's, I was a listing agent, the buyer's agent didn't know this. I was shocked. All right. Paragraph 21, notices. There is a huge risk here if the license holder makes the decision that they will receive notices on behalf of their client. If the agent decides that they want to accept the notices on behalf of their client, they are assuming responsibility for them in order to get the information to their client in a time-sensitive manner. A ton of things can happen in order to mess this up for you. I cannot think of a situation where a buyer or a seller does not have an email address that can be used by the title company and by you and by anybody else that needs to give notice in these transactions, even if it's a family member. I ran into this problem years ago. My client, would you believe, was 94 years old. And yes, he had an email address, but he didn't trust himself with that. So we also added his daughter's email address so that she also got all of the notices and could call him and let him know that he had it and that kind of stuff. It's really, really a high-risk business practice to do this. And Texas Realtors, in a recent publication, cautioned agents about doing that and asked them to think long and hard before they exercise that kind of a business practice. Now, the other thing to remember is that we are legally restricted from signing anything foreign on behalf of our clients. Signing a certified mail receipt, as an example, on behalf of a client, for example, might be outside the scope of our authority and subject to disciplinary action by TREC. That rule might be extrapolated to other notices accepted by a license holder on behalf of a client should something go wrong and a complaint is filed. It's always interesting to know that we have all of these rules, all these processes, all these things that we're supposed to do, and we're supposed to do it now and here and there. And there is no ramification for doing it wrong unless there is a complaint filed. So that puts us back to why we do these things, and that's to prevent anything like that happening to any of us. Now let's take a look at a little bit of time frames. There was an article that came out from Texas Realtors not too long ago, and it made it very clear that when no time frame is stated in a contract, the deadline for giving notice or expiration time is 11/59 on the date stated in the contract. Let's take a look at that, whatever that means. Earnest money deposit, according to the contract, is 11:59 of the 3rd day. But bearing in mind that title companies close at 5 p.m., you may not be able to make that unless you can email and have it date stamped, and the title company will say that it was received by, on the right day. Option period in the contract ends at 5 o'clock on the final day. The extension of any option period in the amendment form ends at 5 p.m. of the final day. And there are 2 blanks in the seller's disclosure paragraph 7B2 of the contract. There is no time frame, so those documents would be due 11:59 in each occurrence. The failure to observe these deadlines may result in your client relinquishing a right under the contract, or even worse, finding themselves in default. And we all know whose fault that's going to be. So pay attention to these time frames and when they're due. And if your earnest money is going to be late on the third day, be sure that if you email it, that it gets date stamped and the title company will acknowledge it on the third day. T47 affidavit. T47 affidavit is the form that is required in paragraph 61 of the contract having to do with the seller's existing survey. The T47 affidavit is promulgated by the Texas State Department of Insurance, and it must accompany existing surveys to be provided to buyers for their use under the contract. Paragraph 4 of the affidavit, the T47 affidavit, asks for a date from which there have not been any changes. Everybody that I know of uses the day of closing of the transaction where the survey was done as the date there. It is not the correct date. It is the actual date on the survey. And you know, the surveys are always dated a few days before closing. It is the date of the survey being provided. The risk of trouble of an incorrect date here is minimal. I don't think anybody's going to go to T47 affidavit jail for putting the date of the closing in. But it's better that we all know the correct date and use it, just because we want to be as perfect as we can. And probably the closing date is perfect enough, but it's not perfect. So the date of the T47 affidavit is the date of the survey that is being conveyed, the existing survey, to the buyer. Okay, buyer approval as to income, assets, and credit history is covered in the third-party financing addenda, paragraph 2A. And in that paragraph, a number of days is entered for the buyer to provide approval from his, her, or their lender as to income, assets, and credit history. If that number of days passes without approval and the lender refuses to fund the loan, the buyers will be at risk of losing their earnest money for failure to timely notify the sellers. The risk of liability here is substantial if the buyer agent fails to correctly monitor the number of days or the date for buyer approval and the loan fails. The buyer agent is vulnerable to have a complaint filed against them for failure to look out for the buyer's best interest, or as they say at TREC, for negligent or incompetent conduct. So what can you do? Monitor that date in red, great big print, on your calendar, on the folder, everywhere you can. And 3 days before the date is up, talk to the lender and see where they are on that. And if they're not ready to say that the buyers are approved as to income, assets, and credit history, this is their personal approval, then you do an amendment, submit an amendment extending the date for buyer approval. And you do that as many times as you have to. Do not let that number of days, which turns into a date certain at amendment time and after that. And what I mean by that is in the third-party financing addenda, it asks you for a number of days. 21 days is probably what most initial contracts have for the buyer to get buyer approval. Listing agents, of course, want it done during the option period, which is crazy. So stay in touch with the lender. At some point, the seller is going to refuse to extend it anymore. And then you have to sit down with your buyers and have a little talk with them. And the decision must be made by the buyers based on the advice of their lender, whether to give notice that the buyer approval has not been received, terminate the contract, get their money back, or if they want to go forward, if they are confident that the approval will come eventually. Just be assured that the buyers are fully informed and understand the situation. It's really important that we do not sit back on our laurels on these contracts. When we have a date, we have to monitor it. It's our job to manage the contract. This is a big part of that, is this buyer approval thing. And the Texas Real Estate Commission has little patience with agents who sit back and fail to monitor their transactions. It is our responsibility to shepherd the sale all the way to closing and to protect our clients any way we can, the best that we can, and document everything that you do. So that's being said, let's talk about surveillance cameras a little bit. Back in November of 2017, Texas Realtor Magazine put out a pretty extensive article explaining the rules about security cameras and the little things that sit up on the bookshelf and record everything that's going on in the room. I think that a lot of us missed this original article because it was just, you know, a month or so after Hurricane Harvey, and thousands of us had other things to do than to sit down and read the Realtor magazine. So, but it's a good article. It's got good information in it, and you can still get it by logging on to Texas Realtors and going to publications and pulling up the Texas Realtor magazine. And it may be in the archives now. It was due to go into the archives. It may be next month, but it may go into the archives already there. So if you don't see it, then you can go in. It's probably in the archives, and you can pull it out from there. And it's on page 24 of that issue, so you can read that and see what it says. But irrespective of that, on advice of counsel, we need to refer our clients to their attorney, as stated in the listing agreement, for explanation of those rules and the consequences. It's the consequences that if we try to explain, we may be accused of practicing law without a license. But we all remember that we've had this one-party rule in effect for years that allows us to record a telephone conversation that we have with somebody else and not tell the other party. And that rule will not help you here. The takeaway is that the party recording is a participant of the conversation. And that's the only way that a conversation in a house for sale, when somebody's there for showing or anything else, can be done. It is construed as practicing law without a license to explain the surveillance rules and particularly the consequences, as I said, to our clients. So let's just follow the guidance in paragraph 21F of the listing agreement. It's really hard to do, but we really need to do that. Broker advise seller to consult an attorney before using any type of surveillance device in the property to record or otherwise monitor prospective buyers without their knowledge or consent. Sellers should be aware that a prospective buyer might photograph or otherwise record the property without seller's consent or knowledge. By the same token, if you have a buyer client and they want to photograph the property, you might have them talk to their attorney about that too, because we don't have permission for them, they do not have permission to take additional photographs other than those that they should rely on, which are the ones in MLS. So that's that story. The consequence of extrapolating from that article and telling your client that the security devices have to come down could have really damaging consequences. Suppose they have a camera system in their house. Now, no cameras can be in private areas of the house, like bathrooms, anyway. But if they have surveillance equipment in their house and you tell them you have to take that down because it's an invasion of the buyer's privacy, and that's what it says, and they take them down and the house is burgled and they don't have any evidence of who did it, who's going to be in trouble about that? So be very, very careful of the advice that you give your clients to be sure that it is proper. And we're going to talk at the end of this about a case that happened when an agent gave a client bad advice, and the consequences that happened there was very unfortunate. So now Texas Realtors published another article in September of 2019, just very recently. And in that article, it restated the one-party rule. And to quote what they say, this rule allowed recording of a conversation as long as one person was aware of it happening. That one person had to be one of the people involved in the conversation. So remember that? We could get on the phone, push record, and it was fine because we were the one doing it. This rule does not apply in any surveillance where the party conducting the recording is absent and not part of the conversation. It says in the article that silent audio is usually allowed as long as it's not in the private area of the house, like the bathroom. And the visitor's privacy is expected. They have the expectation of privacy as they view your house, as they view the house that they are being shown. And as to buyers, conversations with our clients regarding surveillance and photographing property during showings should be along the lines of the text contained in our listing and buyer rep agreement. Saying more, even though we know so much more, is a slippery slope for the unintended practice of law. And speaking of buyers, if they want to take additional pictures, politely say, I have to check with the listing agent to be sure that's allowed. And number two, it might be a good idea to have a personal business practice that as you show buyers property, you have a little conversation with them before you get there and say, I have no idea whether this house is wired for video or not. So while we are inside the house, let's just act like we are being recorded, and we know we are being recorded, and we keep our conversations to ourselves, keep our thoughts and our conversations to ourselves until we get outside. But be careful on the front porch. Those Ring doorbells have audio and video, and it's practically impossible to turn them off. So if you see a Ring doorbell on the porch, signal your clients, point to it, do whatever you can, and don't say anything about how ugly this house is or whatever. Okay. So I think that the thing about surveillance cameras is not over. I think it's a new thing that's come along. And what we know right now is we know too much. We know enough to really get ourselves in trouble. So regardless of what we know, and these two articles are both very, very helpful. They're very helpful. The first one is extensive. It tells us everything, what laws will be broken and what the penalties are if a complaint is filed and all that stuff. And that's what we have to be really careful about. So it doesn't matter what we know. If they want to know more than is what is posted in the listing agreement, in the buyer's representation agreement. Please, 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 for your own sake, refer them to their attorney for explanation. And did you know that we have new title insurance premiums which changed as of September the 1st, 2019? I found out about it, I think, on August the 28th. It was very, very close. Now, the charts that we get from the title company are very helpful. So whatever chart you have from before September the 1st, throw it away and go to your favorite title company and get a new one. And those charts, on one side of them, usually publish the actual title policy premium in $5,000 increments up to $100,000. And then somewhere else, usually on the back of the form or somewhere further into the flyer, you'll find a premium chart. And that talks about how you can calculate the policy of title insurance for the seller to pay for the buyer yourself. And so the good news is the rates went down just a little bit. So I listed two in the PowerPoint for policies of $100,001 to $1 million. And then for those of us that get lucky enough to go into the $1 million range of homes, I also included the formula for homes selling at $1,001 up to $5 million. So looking at the policies of $100,001 to $1 million, the way that you compute the premium is you take the sales price, and when you're doing this for anybody, whether a seller at listing time or a buyer when you're looking to go forward, and they want to know how much the title policy is, on a listing, you can just pick the number that you're going to list the property at. Say that, you know, this number will change based on what the final sales price is, but this will give you a ballpark of what that obligation is going to be. So that being said, take the sales price and subtract $100,000 from it. Take that result and multiply by 0.00527, and whatever the result is, you round it up to the nearest whole dollar. You take that whole dollar amount and you add $832, and that is the cost of the owner's policy of title insurance that the seller will be obligated to pay. And if you're doing this for a buyer, I don't know how to calculate the lender's part of it. That has to do with a lot of things that we don't know. So, but they will know what the amount of the basic premium is that the seller will pay for them, and then be sure that they understand that there will be lender portion that they will have to pay. Now, for policies over $1,001 up to $5 million, take the sales price, subtract $1,000 from the policy amount, multiply that result by 0.00433, and round to the nearest whole dollar. Take that nearest whole dollar amount and add $5,575, and that is the amount of the basic homeowner's premium for expensive homes. The chart goes up from there. You can get policy formulas all the way up to, I think, $5 million to $25 million. It's really quite extensive. But these two numbers here will help you immediately in calculating that amount for your clients, and then you can get your new chart whenever you get to the title company, and they have the, you know, the pocket-sized ones that are really nice too. So anyway, that was effective September 1. I always tell the students in my contract classes when we talk about title insurance premiums to every year check with the title company in January and in September to see if there are any changes in the policy calculations and when they go into effect. This just kind of popped up all of a sudden. So, you know, it was realtors who had it on their calendar to call their favorite escrow officer on September the 1st would have found out then that there's a new chart. So hope you can use that soon. One more time with the seller's disclosure notice, which was mandatory September 1st, 2019. This seller's disclosure notice was revised primarily because of Harvey. It now has a new Section 5, and it is all about flood. This form was mandatory as of September the 1st. This form must be used, accompany all contracts dated September 1st and later. So if you had a contract in title dated before September the 1st, before you go to closing, you must have a new seller's disclosure notice to attach to it. Now, what the new seller's disclosure does is it removes some flood-related entries from Section 3 and moves those to the new Section 5. So you're going to, if you're really into the seller's disclosure notice, you're going to see that Section 3 is a little bit smaller than it used to be. And that establishes a new Section 5 dealing with everything flood. Everything flood. It wants to know the flood zone. It wants to know everything. And it has got a pretty good explanation section at the bottom of the form that will help you help your clients fill it out correctly. And then, so then it has a new Section 6, and that new Section 6 asks if the seller has ever filed a claim for flood. That's ever, not just Harvey, ever. A new Section 7 discusses if assistance has been applied for and received from FEMA, Federal Emergency Management Association, or the SBA, Small Business Association, because of flood. Now, during Harvey, there was FEMA money that was available for people without insurance. I think it was $32,000 maximum. If they were one of those, they have to disclose it here. And then SBA was kind of hanging around during the early months of Harvey, and they were issuing very low interest loans, like 1.75% loans for 30 years for people who either did not have flood insurance or who had inadequate flood insurance. And that also has to be disclosed. And then after that, the former paragraphs of the seller's disclosure notice get renumbered. And then I have down here, just a reminder that listings which were not under contract by September 1st must have the revised seller's disclosure notice accompany any contract that goes into title. It might be a good time to get those listings updated with the new notice if you haven't already done so. Just a thought. So hopefully the new seller's disclosure is alive and well in your forms at library, and that you are up to date with it and you can explain it to your buyers, sellers. Okay, this is a tough one. I have never seen this activity in our board. It's called pay to play. However, I will tell you a little story. Last year, I was on a task force with TREC. The task force was called Broker Responsibility. It was a lot of fun. I really enjoyed it. I learned a lot, met a lot of really big brokers throughout the state, and we did some good work. One day, these are open meetings, by the way. Anybody can come and talk to TREC in these meetings. An inspector he happened to come all the way up from the valley, came in there to talk to the members of this task force and the administrator of TREC, who is in the room, and legal counsel for TREC, who is in the room, about a practice that was going on all over the place down in the valley. And the practice was that brokers were having preferred vendor lists. We all have our vendor lists that we give our clients, but brokers and sales agents were developing these lists, but to get on this list, they had to pay. And there's a TREC rule, by number is 535.148, that limits inspectors from participating in any kind of a scheme where they pay to get a referral. So it's always been a violation of TREC rule for the inspectors to do that. And so the inspector that was there said, help, what can we do? We can't pay to get on the list, and so we don't get refers, and the inspectors that do go on the list and pay are in violation of TREC rule. So anyway, TREC expanded the rule. And it says now that you cannot pay or receive a fee or any other valuable consideration from or any settlement service provider. That includes the referral of inspectors, lenders, mortgage brokers, or title companies. For inclusion on a list of inspectors, preferred settlement providers, or similar arrangements, or inclusion on lists of inspectors or other settlement providers contingent on financial arrangements. But they put a little bit of an exception in there to give the brokers and the agents who want to have this business practice some wiggle room to be able to do it. And the exception has to do with if the broker or salesperson, with their broker's permission, of course, wants to have a referral list where people pay to get on the list. The broker can charge a fee. Broker can do that if it's made clear on the face of the list that the ranking is based solely on advertising rates paid by the vendor. And the fee has got to be reasonable. It's got to be within market rates. And it says a broker can engage in legal, promotional, or education activity to or with settlement service providers that are not conditioned on referral of business. So I have, and I think the majority of the license holders in our board have our own personal vendor list that we give our buyers when we put them under contract as possibilities for them to consider using during their transaction. And this pay to play does not apply to our personal list. As long as there's no charge to the vendor to be included, you're good. But I wanted to mention it to you because this inspector came all the way from the Valley up to Austin to talk to the Broker Responsibility Task Force about this. And TREC listened, and TREC changed the rule to make it really clear that the only way that a broker can do that is to make it clear on the face of the listing how they were ranked and how they came to be. And it can't be just because they paid the most money. So I thought that was kind of interesting when they came out with this, and I thought I would pass it along to you. Now, I talked a little bit earlier about the danger of giving bad advice. This is a story that was published by Texas Realtors, and I read it and I said, oh my goodness, this could happen to anybody. And you think, how many times, particularly with buyers, they'll ask us a question and we wing it and we give them an answer. Most of the time it's probably, you know, within reason and nothing happens. But what happened here was that a real estate agent was working with a buyer, and there's a purchase agreement, of course, and it had HOA restrictions, and the agent actually misinterpreted some of the rules when the buyers asked them if it would be okay if they removed some trees on the property. And the agent said, yeah, that's fine. After the buyers moved in, they cut down a whole buffer of trees near the rear of the property because they wanted to improve their view. Well, there was a deed restriction requiring written approval by the board for removal of certain vegetation. And the agent just, I don't know if she missed it, didn't read it, was winging it, or what. But after it was done, the adjacent neighbors filed an emergency motion for temporary injunction to keep them from cutting down any more trees. And what happened was the buyer sued the real estate agent, alleging he provided legal advice without a license and breached the standard of care by a real estate professional. They also said he failed to recommend a consultation with a real estate attorney. When the agent admitted to his broker that he committed an error in judgment, the lawsuit was resolved and they replanted the trees, and a payment for his clients was involved, and who later filed a claim for reduced property value because of it. So, how do I go back? Those are the kinds of things, especially about deed restrictions. Even if you have a buyer in your own subdivision, please be very careful about quoting anything that might be in the deed restrictions. After all, when was the last time you read yours? Have you ever read yours? Do you know what this says? And some agents, when they order the HOA docs, they sit down and they read this stuff. But the fact that they sit down and read this stuff doesn't mean that they've got carte blanche to quote to their client what it says. Because as in this case, the agent either missed that sentence or he misinterpreted it, but he gave the buyers bad advice and it ended up really, really bad. So it's okay to refer them to an attorney. If you see something in the deed restrictions as you read them, what I have done, and I think it's okay for you to do, is to point it out to them and say, this is what I found in the deed restrictions about the subject you asked me about. I need you to call your attorney and see what he says the resolution to your question should be. You don't answer their question, you're not an attorney. That's all. All right, moving right along. We have possible, maybe, it might happen, it hasn't happened yet, possible changes to our contract. These changes were proposed in August at the TREC meeting, and whether they will be implemented or not will be determined by the TREC meeting in November. I think it's around the 10th or 11th at their meeting. And if these proposals are adopted, and there's no reason to believe that they will not be, the scuttlebutt is that they're probably going to go through. Don't know that for sure, but until officially approved for implementation, these changes remain proposed, unapproved, and are given to you today for a heads up only about what might be coming in November. Okay, so these are possible draft changes just so you can think about it. They were presented to the Texas Real Estate Commission in August. They went out for comment in August. The time to comment has ended, and at the next TREC meeting all the comments will be discussed and they will decide what the changes are going to be and what the changes are not going to be. So I have a copy of the red line, and I will go over the contract changes for you as proposed. Proposed. Paragraph 4 used to have the license holder disclosure. You remember that one? That's the one where we have to disclose, both as a listing agent and a buyer's agent, if we were working on behalf of a family member, or if it's a business and we have an interest in it, or whether we're involved in a trust for the property. That paragraph that has been moved, it's not taken out of the contract, it's been moved, and in its place goes a paragraph about leases. And I don't think this is the right place for it, but they didn't ask me. It says that in addition to the part that used to be in the contract that says that the seller will turn over all the documents and so on and so forth to the buyers of any investment properties, it goes on to talk about the following types of leases to which the seller might be a party, including addendums, amendments, or moving condition forms for leases, oil and gas, mineral leases, leases of fixtures, for example, solar panels, propane tanks, and water softeners, or other. And then it talks about the buyer either has received a copy of all the leases, or the buyer has not received a copy of all the leases, and that the seller has so many days to do it. So that's what's going to be maybe in the new paragraph 4. So unless you are dealing with an investor that has got lots of properties that will be sold subject to the lease, this probably will not be of much interest to you. Paragraph 8 used to be a paragraph called broker fees, and that simply said that our broker fees are contained somewhere else, and they're in the listing agreement only. And the title of that paragraph was changed to read license holders, and the first paragraph remains the same, and then here comes the paragraph that was removed from paragraph 4 about representing a parent or business entity or being involved in a trust for the property. So I just moved that other paragraph here and changed the title of the paragraph to license holders. No big deal. Buyer's possession, paragraph 10, you'll see that what changed was in paragraph B, it crossed off the word leases, and it just says after the effective date, seller may not convey any interest in the property without buyer's written consent. And it took the paragraph out that that says that the seller will deliver copies of leases, move-in documents, blah, blah, from here because it's now in paragraph 4. So it's no big deal. Just move stuff around a little bit. This is kind of a big one. On the broker information page, down at the bottom where it puts in there that the listing agent has agreed to pay other brokers some percentage of the total sales price is out. It is out of all contracts except farm and ranch. So we will no longer put on the information page, if passed, this part about what the offer of compensation is. And now I understand that what's going to happen is if this passes, listing brokers will notify the title company of the offer of compensation and how it will be divided, possibly by way of a commission disbursement authorization or some other vehicle that will be a required form that the title companies will be bugging listing brokers for. And the reason that it was taken out of the contract is because there's a paragraph in here that says our fees are covered someplace else. And so they took it out. So it is true that our fees are covered someplace else. And on the HOA addenda, down in paragraph C that talks about fees, it just added a couple of words. It added the word deposits, reserves, and crossed off the word or. You see that? The charges associated with the transfer of the property not to exceed some amount, and seller shall pay any excess. The foundation dues that so many subdivisions are charging now are properly includable in this paragraph. So don't forget to put them in, and listing agents, be sure that the number is in there, or the seller may get stuck with paying that fee, which is usually a buyer's fee. Now, third-party financing addenda. Couple of changes, and we're almost out of time. I'll try to get through this real quick. The approval of financing, paragraph 2, just has a little sentence added that time is of the essence in this paragraph, and that's in the one where you have so many days to get buyer approval. They're just telling you to pay attention to the time frames. And on the paragraph C that says time is of the essence for this paragraph is removed because they just moved it up to paragraph 2. And paragraph 4 has to do with the FHA VA required provision. And the only thing that's added there is that the 3-day notice of termination requirement in the buyer approval paragraph above 2B does not apply to this paragraph 4. It's in there that they get their earnest money back without ado if it doesn't appraise, but they just moved it down here to make it more clear. And the addendum for hydrostatic testing, you've changed just a little bit to add in, take away the word hydrostatic and just kind of reworded the top part. Now that's it for today. I hope that this webinar has been informative to you and that you can use the content in your business to stay more current and catch other people who are not, by the way. So our goal is to provide you with as many nuggets as we can to help you through a transaction. We hope this is done well. And do we have anybody has any questions? It looks like nobody has any questions. So hopefully we took care of everything for you. My contact information is on the screen. My email address is nancy@nancyherzig.com. And my telephone number, where is the T47 available? Oh, here are some questions. Where is the T47 available? The TR website, HAR Forms Manager. Yes, it's there in all those places. You'll find it in the library that you are using. Whatever library you're using for your forms, you will find it there. With that,
I'll send them the follow-up email.
The follow-up will be sent to you, and we'll send you also the PowerPoint so that you can look at it.
And the links to the articles
Okay, good. And if you have questions and want to ask me personally, feel free to contact me. Either email me, text me, or call me at 281-734-0506 is my cell phone. Okay, then there's a question here. Will there'll be a rebroadcast of this? The training was the best I have seen. Oh, bless you so much. We are so happy that you liked it. What should we do in case of the surveillance camera issue? I think the thing you should do is explain to them that there may be a problem with them having surveillance cameras with audio and video, and that they should call their attorney and find out what to do. Does the buyer agent read? Oh, if I heard right, does the buyer agent read the community bylaws? I think that it's a good idea if you do read the HOA docs that come in. There are things in there that the buyers may gloss over or not know what it is, such as in the resale certificate, it says whether there are any special assessments coming. In the resale certificate, it says if there are any lawsuits pending. Those are things that are very important, and you need to point them out to your buyers if you see them. We don't want you to talk to the buyers and the sellers about the content, specific content of those articles on surveillance that I mentioned, because of the potential of messing up so that they take the cameras down, their house is ripped off, and it's your fault. Refer them to an attorney for the attorney to say, well, I've never heard of anybody suing because of that, so either take them down or roll the dice, whatever you want. Let the attorney say that to them. What if they don't have an attorney? You should have an attorney and don't want to get one. That's fine. That's their decision. That's their decision. I just think you just need to tell them what it says in the listing agreement and in the buyer's rep agreement, and if they don't want to comply, that's entirely up to them. But if they tell you they don't want to comply, please put a note in your file that you've suggested that, and that they just ignored you. Last question. What should we do if the buyer did not elect an attorney after the buyer agreement has been signed? If later when we deed restriction HOA, what would we advise our buyers as far as an attorney? You can have a list of attorneys on your referral. You can do that. You can talk to your broker about what he would like you to do in that case. I think that would probably be the best thing. But the thing we have to do is we have to get information from our heads to our clients without being accused of practicing law. And the thing that concerned me about this is, while I love these articles, I absolutely love them because of the content and because of the information that's in there and the education qualities of it. They don't go far enough about warning us about, well, this is good information, but go by the listing agreement. The HAR attorney gave me that bit of advice, by the way. What about new homes and HOA dues? What about new homes and HOA dues? I don't know what that means. The HOA dues should be in the subdivision, should be in the builder documents that they go through. No. Is there a TREC form waiver that clients can sign if they refuse attorney advice? No, but you could just ask them to send you an email saying that they talked to an attorney and they refuse to take their advice. What you need, guys, is you need a paper trail of who you referred them to. And if you get any feedback from that referral, then you should document that too. Because what I'm trying to help you avoid is a complaint that says, you didn't tell me something you should have told me. Well, because it's practicing law, I told you to get an attorney. So see how that goes? This isn't a big deal, but I just don't want it to be a big deal. So we have to stop now. Thank you so much for being here with us today, and we'll try to do something more for you very soon. Bye-bye. Thank you.